In this video, we're going to continue our series on the hearsay objection and its exceptions by talking about excited utterance. And I'll be honest with you, this particular hearsay exception is deceptively complicated. So let's break down excited utterance and provide an example so you can be one step closer to mastering hearsay. Welcome to Law Venture, a channel devoted to lawyers and future lawyers. My name's Jarrett Stone. I'm the owner of Stone Firm P LLC, and today I am your guide to talking about excited utterance. And since we're talking about objections, because hearsay is an objection, I recommend that you check out this bad boy right here, the free objection cheat sheet, which you can get by going in the description down below. This is absolutely fantastic because it goes through the 21 most common trial objections and boils it down into a simple cheat sheet. And the craziest part to me is that this cheat sheet has been downloaded over 5,000 times. That's absolutely crazy to me. Anyways, check that out. It's in the description down below. Okay, enough of that. Let's get back to talking about excited utterance. The first thing that we need to do is keep in mind that excited utterance is one of 3 hearsay exceptions that fall under the spontaneous category. If you have no idea what I mean when I say spontaneous category, that probably means that you haven't seen the hearsay exception video that I have on present sense impression. I recommend that you check this video out because we're building upon that particular video with this particular video. So for your convenience, I'll slide the present sense impression video. Check that out, pause me, I'm not going anywhere, watch it, and then come back here so we can build upon that video for a greater understanding on how excited utterance works. After you've watched that video, it's time to continue forward. Like with present sense impression, when we're dealing with excited utterance, we never want to get too excited to where we overlook that the statement still needs to survive Rule 402, which is relevance, and Rule 403. We also don't want to overlook the fact that for dealing with a hearsay exception, we need to make sure that it's actually hearsay, meaning that it's not non-hearsay, double negative, which means it is hearsay. So assuming that the statement survives 402, 403, and the statement is not non-hearsay, again, double negative, means that it is hearsay, now it's time to start talking about whether or not a hearsay exception applies. And for the purpose of this video, again, we're talking about excited utterance. So let's go through the analysis on how excited utterance works. Under Rule 803, exceptions to the rule against hearsay, Rule 803.2 states excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. So with Rule 803.2, excited utterance, we're dealing with a startling event that the declarant has personal knowledge on and has made a statement while under the stress of the excitement, to where that excitement has led to the statement being spontaneous. I know that's still abstract, but bear with me here because I think we need to take it step by step to ultimately get where we're trying to go. The next step that I always do is, after reading the particular rule, is to go check out the advisory committee's notes. Let's do that. The first part that we want to look at under the advisory committee notes is this part showing right now. The theory of exception, paragraph 2, which is excited utterance, is simply that circumstances may produce a condition of excitement which temporarily stills the capacity of reflection and produces utterances free of conscious fabrication. In other words, we have a spontaneous reaction and a spontaneous statement to an exciting event. The next note states that while the theory of exception, paragraph 2, aka excited utterance, has been criticized on the ground that excitement impairs accuracy of observation as well as eliminating conscious fabrication, it finds support in cases without number. So what this note tells me, if I read in between the lines, if I see the hint being suggested, is that if I'm the lawyer making the hearsay objection, opposing the statement that's being brought in, and unfortunately what ended up happening was opposing counsel was able to successfully argue excited utterance, all that happens, and that statement does come in through excited utterance, what I need to do at that point in time is wait for my cross-examination and paint the picture that the statement doesn't have credibility because the declarant's senses and perception were impaired by the stress of the situation and hope that I'm able to convey that with a killer cross that ultimately registers with the jury. That's just a quick tip, so let's move on. As we know from the present sense impression video, the key element and the key factor with present sense impression exception is how much time has passed between the event and the statement itself. We have a bit of a similar analysis, but also different analysis when it comes to excited utterance. In particular, the note states that under exception paragraph 2, aka excited utterance, the standard of measurement is the duration of the state of excitement. How long can excitement prevail? Obviously, there are no pat answers, and the character of the transaction or event will largely determine the significance of the time factor. So basically, there is no bright line rule that says, hey, at this minute mark right here, excited utterance no longer applies. Instead, this means that we have to conduct a case-by-case factual analysis. And the question is, how do we conduct this factual analysis then? Well, the answer is going to depend on your jurisdiction. But what I want to do is provide you a case example coming out of the state of Texas, which is my state, that really simplifies the step-by-step process in doing this factual analysis on excited utterance. But again, I'm going to stress the fact, this is my excited utterance in the moment where I'm paranoid somebody is going to just rely on a Texas case when they're not in the state of Texas. Look up the case law, look up the rules in your jurisdiction, and see if you have something comparable to what I'm about to show you. So I have the case pulled up on PDF Expert. And by the way, I'm a huge fan of PDF Expert. If you haven't seen my other videos, if you're curious on checking it out, I have a link down below. Just in case you want to do your own legal research at home, because I know how exciting that can be. The case is Zuliani versus the state of Texas, coming out of Texas Court of Criminal Appeals back in 2003. Now let's get started with the definition of excited utterance, see if that's any different from the federal rule that we were looking at earlier. In particular, it states, an excited utterance is, quote, a statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. This is Texas Rules of Evidence 803-2, which is identical to the federal rule of evidence that we were just looking at. So the analysis when it comes to federal versus the Texas analysis is going to be pretty comparable. Now, the court says that the basis for the excited utterance exception is a psychological one, namely the fact that when a man is in the instant grip of violent emotion, excitement, or pain, he ordinarily loses the capacity for reflection necessary to the fabrication of a falsehood, and the truth will come out. In other words, the statement is trustworthy because it represents an event speaking through the person rather than the person speaking about the event. I absolutely love the way the court put that. In determining whether a hearsay statement is admissible as an excited utterance, the court may consider the time elapsed and whether the statement was in response to a question. However, it is not dispositive that the statement is an answer to a question or that it was separated by a period of time from the startling event. These are simply factors to consider in determining whether the statement is admissible under the excited utterance hearsay exception. Now, here's the important part that I really want you to pay attention to. The critical determination is whether the declarant was still dominated by the emotions, excitement, fear, or pain of the event or condition at the time of the statement. Stated differently, a reviewing court must determine whether the statement was made under such circumstances as would reasonably show that it resulted from impulse rather than reason and reflection. So this last part of impulse rather than reason is what gets us, if we bring it full circle, to the fact that excited utterance falls under this spontaneous category. Now it's time to make the abstract more concrete by way of example. Let's use the same declarant/influencer from the present sense impression video, but change the facts ever so slightly. Let's say in the aftermath of the wreck, the declarant/influencer walks up and ends up approaching the defendant. In that moment, the defendant threatens the declarant and states that if the declarant ends up talking to the police about what she saw, the defendant's going to do something horrific to her. Concerned about her safety, the declarant decides to just leave the scene. She goes home. And then 24 hours later, The police knock on her door. They somehow figure out that she was at the scene and they just want to get a simple statement from her. Declarant opens the door, see the police, and the police ask her, "Can you give us your perspective on the wreck that you saw yesterday?" The declarant ends up telling her side of the events. Fast forward 6 months. No, we can't have a trial in 6 months. That's just ridiculous, Jarrett. Fast forward a year and a half later, and we're at trial. You represent the plaintiff. The defendant has obviously a very hardcore defense attorney who wants to object to anything and everything. And so what you need to do is get the statements from the declarant introduced into evidence, but unfortunately the declarant can't make it to trial for whatever reason. So anyways, you end up calling the police officer to the stand who spoke with the declarant. The police officer wants to quote the declarant, but unfortunately that defense lawyer is wanting to object, and he stands up and he objects to hearsay. As a result, the judge looks at you and asks, "Do you have a response, counsel?" And your response to that is, "Your Honor, this particular statement satisfies the excited utterance exception." But the question is, does it really? If your gut reaction is, whoa, Jarrett, you have not given enough information on what was said, what the police officer saw, what all went into the conversation, were there follow-up questions, what did she look like, what were the facts and circumstances surrounding the particular statement, then you've been paying attention. So if the facts end up showing that whenever the police arrived and asked a very open-ended question to the declarant, that the declarant looked like she wasn't maybe taking care of herself for the last 24 hours, that she was a mess, she looked fearful for her safety, she was trembling while she was answering, or she was crying while she was answering the question asked by the police officer. If you have evidence like that, then you can have a very strong argument that excited utterance does in fact apply, despite the fact that the statement occurred 24 hours after the car wreck and 24 hours after the defendant's threat. You'd also want to look at the questions being asked by the police officer. Are they open-ended questions not suggesting any kind of answer that maybe the police officer is trying to elicit from the declarant? Or are they leading questions that are trying to elicit specific answers from the declarant? The goal here is to have a set of facts proving that the declarant was still being dominated by the emotions, excitement, fear, or pain of the event or condition at the time of the statement, with the event or condition being either the car wreck in this situation or the threat by the defendant. So we're going to be arguing that the statement by the declarant in this situation was made by impulse and was spontaneous. Opposing counsel, when it's his time or her time to respond, they're going to be arguing that the declarant within those 24 hours had enough time to reflect on the future statement and the effects of such statement. Quick timeout for a pro tip. The last thing you want to do if you're trying to keep the statement out, so in this situation, if you're on the defense, is argue everything in front of the jury, because even if you win the argument, if the jury ends up hearing the statement, you may have an issue there. So what I recommend doing is filing a motion in limine, and what you may need to do is take the witness on voir dire to show the facts suggest that excited utterance does not apply, or maybe you even anticipate the statement being introduced by getting the facts during a deposition and then presenting that in your motion in limine to the court in advance outside of the presence of the jury. Okay, at this point, I think we're all set with excited utterance. If you have any questions, thoughts, comments, concerns, or if you just want to say hi, leave those in the comment section down below. As always, if you're still watching, don't forget to hit the like button. Helps support the channel, allows us to reach more people, to help more people, and don't forget to subscribe as well. With all that said, I'll see you in the next video.